Tom Abbate, and today we're going to talk about family violence crimes. Now, these are essentially normally defined crimes with additional elements. Okay, so for instance, assault and assault family violence are essentially the same crime, but there are differences in how they are handled and what the results are based on the nature of the relationship between the complainant and the defendant. Normally on an assault charge, it's just intentionally or knowingly either causing harm to someone, making them feel like you're going to cause harm to them, or actually causing serious bodily injury and things of that nature. As far as the assault portion goes for, say, a charge like assault family violence, these are largely lined up the same in terms of the elements that need to be proved. The only difference is that under assault family violence, the state has to prove an additional element that defines that relationship between the parties. So, for instance, if I get into an altercation with someone on the street that I don't know, we have a fist fight, that is going to be a normal assault charge. But if I'm at home with my significant other, and we get into a fist fight, that is going to be a different charge called assault family violence. And what the state will need to prove additionally is that we're either married, related by blood, or are dating. Essentially, there's two different codes. In the Texas Family Code, one section outlines basic family member relationships, and this can be by blood or marriage, so your child, your spouse, anything like that. And then there's also the section that covers dating violence, which essentially defines someone that you have a romantic partnership with or had a romantic partnership with. So it's your current spouse or your current partner and or an ex. But if you get in charged with something like this and the state proves its case, you could end up with a family violence finding against you. And that is important to note because it has some additional consequences that you wouldn't see under a normal assault charge. For instance, if there's a finding of family violence, you can never get your records sealed. So if you get it, let's say you work out a plea bargain where you're going to take deferred on a simple assault. If you complete it successfully, you can petition the court for an order of non-disclosure. Your records can be sealed, and it shouldn't show up on a normal criminal background check that might be run by, say, a company that you're trying to get hired by. If there is a family violence finding, the court does not have the authority to grant that petition for non-disclosure. It will never be sealed, and it will always show up on any criminal background check that anyone runs against you. So it's very important that you keep that in mind when thinking about any potential resolutions that aren't either a dismissal or an acquittal. Second, your family, and this is where it gets really important, the finding of family violence will negatively impact your ability to own, possess, and use a firearm. Even if you're convicted of misdemeanor family violence, say, you and your significant other get into a fight, one of you slaps the other one, they get charged with assault family violence, they end up working out a plea, maybe they got it over and done with 5 days in the county jail. They're not going to be allowed to own a gun. Okay, there's going to be significant restrictions on them going forward in terms of whether or not they can ever get that firearm. If they have firearms, they'll have to get rid of them. And this is all even though they weren't convicted of a felony, which is usually the only way to get your right to bear arms jerked away from you. Now, with regard to the individual charges, it largely follows the pattern that normal assault charges follow. For instance, an unwelcome form of contact, say a slap or a grab on the arm, is going to be a misdemeanor typically. Verbal altercations are not really going to be dealt with too much unless you're saying something like, "I'm going to kill you," which is a actual threat that could make someone afraid for their life, obviously, which, makes that an assault charge. However, where you see some differences is up at the felony level. For instance, normally an assault family violence would fall under misdemeanor, but if you've been convicted of it before, the second one becomes a felony. It's charged as a felony, and you have to deal with the fact that you've already committed family violence or been found to have committed family violence once before. Second, we have a specific charge of assault family violence strangulation. Okay, this is where two people, lovers or partners or spouses, get into a fight or an argument, and one of them grabs the other one by the throat. That's automatically a third-degree felony. Okay, it doesn't start out as a misdemeanor and move up based on the facts. It's just a felony. Okay, if you strangled them, the state will have to prove that air was cut off, and that the complainant felt that they could not breathe. But so long as, even if it wasn't a strangulation that would result in almost death or even getting close to death, if the airway was cut off at all for any length of time, it's a felony. It's 2 to 10, and it has some very serious ramifications.